Today, we begin with a development that immigration attorneys, senior advocates, and legal experts had feared, dismissed as unlikely, and quietly prepared for behind closed doors. A change that unfolded not over years of legislative debate, but in a single administrative cycle, a single cycle that left thousands of older Americans scrambling for answers, a single cycle that exposed gaps in legal knowledge that no one warned them about, a single cycle that put the citizenship status of naturalized Americans, many of them over 60, suddenly, shockingly at risk. What the federal government did this year crossed a line that constitutional scholars had hoped would hold. And when that line shifted, immigration law firms across the country did not hesitate. They responded with urgency, precision, and an unprecedented flood of public warnings. For several years now, there had been signals, not headlines, not formal announcements, just signals, that federal immigration enforcement was preparing something unusually sweeping. The U.S. Citizenship and Immigration Services, known as USCIS, has always been methodical, yes, but they have been increasingly aggressive in their methodology. Their policy moves have followed a certain pattern, a rhythm, almost a predictability. But what set off alarm bells in immigration legal circles this year was that the pattern went silent. Attorneys who monitor USCIS policy updates know the indicators, the regular publication of proposed rule changes, the quarterly updates to naturalization guidance, the routine announcements to legal aid organizations, the gradual, telegraphed rollout of new compliance requirements. All of that went quiet. And whenever federal agencies go quiet on something this significant, it means something is about to get very loud, very fast, and often without enough warning for the people most affected. That silence, it turns out, was not a pause. It was preparation. Earlier this year, immigration attorneys detected what they described as a significant tightening of denaturalization review procedures, including enforcement actions targeting naturalized citizens that had not been pursued at this scale in over 3 decades. These are the kinds of mechanisms that the Department of Justice only activates when it is signaling something very specific: a policy shift, a political message, or a genuine enforcement priority. Legal observers didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that the government was changing its posture toward naturalized citizenship. And when the federal government shifts its enforcement posture without public explanation, even by a small bureaucratic measure, every immigration attorney in the country pays attention. For Americans over 60 who became citizens through naturalization, this shift carries weight that younger naturalized citizens may not fully feel. Many of you went through the naturalization process years ago, even decades ago. You raised families here. You built lives. You voted in elections. You paid taxes. You served communities. And yet, the legal ground beneath naturalized citizenship is not as fixed as many people believe. That is the uncomfortable truth at the center of this story. The alerts issued by immigration legal organizations this year were not routine. They were not symbolic. They were not procedural. They were urgent. Attorney after attorney, briefing after briefing, described the current enforcement environment in terms that should make every naturalized American over 60 sit up and pay close attention. The descriptions included words like unprecedented, retroactive, and, perhaps most importantly, quietly implemented in ways that gave affected individuals almost no time to respond. Here is what makes this especially serious for the 60-plus community specifically. Many older naturalized citizens naturalized under rules, forms, and procedures that look quite different from today's standards. Documentation from 20, 30, even 40 years ago may be incomplete by modern filing expectations. Records held by USCIS may contain clerical errors made at the time of processing. And in today's enforcement climate, those old errors that were never the applicant's fault, are being examined with fresh scrutiny. Within months of these enforcement priorities being quietly activated, immigration attorneys began receiving calls from naturalized citizens who received unexpected correspondence from federal agencies, not deportation notices, but something more disorienting: requests to verify, redocument, or explain aspects of their original naturalization applications. These weren't ordinary records requests. These were formal inquiries. the kind of inquiries that, if not handled correctly and promptly, can initiate a denaturalization proceeding. Tonight, legal sources confirmed that USCIS and the Department of Justice have launched administrative review actions on naturalized citizens, including individuals who naturalized decades ago under circumstances that federal attorneys now believe warrant reinvestigation. The government moved before many of those citizens realized what was happening. They targeted individuals with any gap in travel documentation. They targeted individuals whose original sponsors or witnesses are no longer reachable. They targeted individuals whose application records contain inconsistencies, even minor ones, that were overlooked at the time of approval. In other words, the government has targeted the administrative vulnerabilities, the paperwork seams, of naturalization processes that occurred long before digital record keeping, long before modern verification standards, and long before anyone imagined this level of review was possible. This is what makes the situation so urgent for the 60-plus community. Your naturalization wasn't just symbolic, it created a legal record. And that legal record, however old, is now being treated as a live document subject to contemporary enforcement standards. That represents the kind of exposure that could result in denaturalization proceedings if left unaddressed. And immigration attorneys understanding that fully are urging older naturalized Americans to respond with action, not panic, not passivity, but proactive, strategic documentation. They're not saying, ignore this and hope for the best. They're not saying, this will never happen to you. They're saying, locate your naturalization certificate, verify your records with USCIS, consult an attorney if you've received any government correspondence about your citizenship, and do not wait. And here is where the story becomes even more layered. Legal analysts now believe that the government's latest posture was designed partly to test the institutional capacity of legal aid organizations to respond after years of budget pressure on immigration services. The question being implicitly asked, would older, vulnerable, naturalized citizens have access to the legal guidance they need in time? But instead of a vacuum, the opposite has emerged. Immigration attorneys, senior legal aid centers, and advocacy organizations didn't retreat. They mobilized in ways that were so coordinated and so rapid that the volume of public information now available to affected seniors is actually greater than it was 12 months ago. You don't get that kind of institutional response without genuine alarm behind it. But today, that mobilization has given older naturalized Americans something critically important: time and information. A senior immigration attorney speaking with a national legal outlet described the current environment using a term worth understanding: proactive vulnerability. It means that people who take action before a problem formally arrives are in a vastly stronger legal position than those who wait to respond after correspondence lands in their mailbox. Proactive response is not only possible, it is decisive. The attorneys who are most emphatic about this are those who have already represented older naturalized citizens in denaturalization proceedings. They say those cases are harder to defend after the process starts than before it begins. That element matters because it shows something important. Naturalized citizenship is legally defensible, but that defense requires documentation, and documentation takes time to gather. It shows that older Americans are not passive recipients of whatever the government decides. They are legal actors with rights, and those rights are best protected by those who understand them. As reports continued emerging throughout the year, we learned more about the actual scale of this enforcement environment. Attorneys in major metropolitan areas reported a significant uptick in clients over 60 seeking naturalization record reviews, driven entirely by fear that old paperwork issues could now create new legal problems. Legal aid organizations reported that cases involving naturalized citizens who had been U.S. residents for more than 20 years were now showing up on their dockets in categories that simply hadn't existed a decade ago. Federal case monitoring groups operating across multiple jurisdictions reported that denaturalization filings, while still a relatively small number in absolute terms, had increased at a rate that no one in the legal community expected to see at this point in history. This wasn't just a policy signal. This wasn't just bureaucratic housekeeping. This was a structural shift in how the government views the permanence of naturalized citizenship. And structural shift is the one thing that older naturalized Americans have historically not had to prepare for. For every assumption of permanence they held, reality has introduced something that complicates it. Remember, many naturalized Americans over 60 assumed that citizenship, once granted, was unconditional. They assumed that the passage of time made their status more secure, not less. They assumed that good civic standing, no criminal record, active community participation, decades of tax compliance would insulate them from scrutiny. But tonight, the exact opposite logic is operating in some corners of federal enforcement. The passage of time is being used not as evidence of stability, but as a period in which to search historical records for procedural irregularities. Good civic standing is acknowledged but not treated as a legal shield against administrative review. And decades of life built in the United States, family, property, contribution, are not automatically factored into denaturalization proceedings the way many seniors assumed they would be. What makes this moment so serious and so personal is that the enforcement shift is happening at a time when older Americans are already navigating enormous pressure on multiple fronts. Fixed-income households are managing rising costs. Adult children are stretched thin and may not be closely monitoring legal correspondence on their parents' behalf. Many seniors in immigrant communities are navigating language barriers that make formal government correspondence difficult to interpret without help. And community legal aid organizations are themselves operating under resource constraints that limit how many cases they can absorb. Seniors in this position are balancing these realities while simultaneously being asked to locate and verify documents that may be 30 or 40 years old, documents that may have been stored improperly, lost in moves, or damaged over time. And when people in that position receive unexpected correspondence from a federal agency, the response that feels natural, set it aside, wait and see, hope it resolves itself, is the exact response that creates the most legal risk. USCIS's current enforcement guidance, now distributed to immigration attorneys through official channels, was designed to signal that the agency is not willing to allow naturalization records to remain unexamined simply because of their age. Officials stated plainly that naturalized citizenship, like all immigration statuses, is subject to ongoing legal validity, and that administrative errors or material misrepresentations discovered after naturalization remain actionable, regardless of how much time has passed. That is careful legal language for, we are telling you that old cases are not closed cases. You do not usually hear that framing from USCIS in such explicit terms unless something structural has shifted in enforcement priority. This is not a scare tactic. This is a documented policy posture that immigration attorneys are treating as a serious operational reality. Meanwhile, senior immigration advocates addressed their communities in urgent, plain-spoken terms at town halls and community forums across the country. They said, "Do not assume that the citizenship certificate you received 20 years ago is sufficient protection in today's environment without knowing what is in your file." They said, "If you have received any letter, notice, or inquiry from USCIS, the Department of Homeland Security, or the Department of Justice, do not respond without consulting an attorney first." And they said, "The most important thing you can do right now is take a single afternoon to locate your naturalization documents, review what you have, and identify whether there are any gaps that a legal professional should see before anyone else does." These are not rhetorical flourishes. These are statements from experienced advocates who understand just how high the stakes have become for the 60-plus naturalized community in 2026. Here is what makes the situation even more layered. The enforcement shift isn't isolated to one category of naturalized citizen. Along with the primary review of old naturalization records, secondary pressures are accumulating simultaneously. Travel records for naturalized citizens who spent extended periods abroad, particularly in the years just after naturalization, are being reviewed for compliance with continuous residency requirements. Naturalized citizens who had any contact with federal agencies in other contexts, including benefits programs or property transactions, are finding that those records are being cross-referenced with immigration files in ways that weren't previously standard. And legal name changes, address changes, or family structure changes that occurred after naturalization but were never formally reported to USCIS are now being flagged as potential administrative inconsistencies. All of this is happening within the same enforcement window. When the government moves multiple review mechanisms simultaneously, it means something more systematic is underway than any single policy change would suggest. Immigration attorneys are now helping their clients navigate several distinct possibilities. One is that a naturalized citizen's file is entirely clean, and a professional review confirms that, providing genuine peace of mind. Another is that a file contains administrative errors that were made by government processors decades ago, errors that are correctable through formal legal channels before they become problems. A third possibility, the one concerning advocates most, is that a naturalized citizen receives formal correspondence without having taken any prior action and then has to respond to a government inquiry without having had time to gather documents, consult counsel, or understand their rights. Proactive action takes that third scenario off the table. Here is what senior immigration attorneys recommend, specifically for naturalized Americans over 60. First, locate your original naturalization certificate. Know where it is. If it has been lost or damaged, begin the process of requesting a replacement through USCIS Form N565 now, before any inquiry arrives. Second, request a copy of your immigration file from USCIS through a Freedom of Information Act request. This allows you to see exactly what the government has in your record and to identify any errors before they become leverage. Third, if you have received any correspondence from any federal agency that references your citizenship or immigration history, consult an immigration attorney before responding. Fourth, if you spent significant time abroad after naturalization, particularly continuous periods of more than 1 year, speak with an attorney about whether your travel history presents any documentation needs. What we are watching now is a test of institutional resilience. The government wants to see whether older naturalized Americans are organized enough, informed enough, and legally supported enough to protect themselves effectively. Advocates want to show that this community is not isolated, not uninformed, and not without resources. The legal system wants to prevent irreversible harm to individuals who built their entire lives on the foundation of a citizenship status they earned legally and in good faith. And the broader public wants to prevent a precedent in which decades of lawful civic life can be undone by administrative re-examination without meaningful access to legal defense. Tonight, we have heard from legal organizations who are now actively monitoring the volume and pace of USCIS administrative reviews of naturalized citizens. They say the window for proactive action is open, but it is not permanent. They say the naturalized citizens who fare best in this environment are those who review their records early, retain counsel before any formal inquiry arrives, and do not allow correspondence from federal agencies to go unanswered or unreviewed by a professional. And they say the government's decision to pursue this level of review is likely part of a broader enforcement strategy intended to reestablish the principle that naturalized citizenship carries ongoing administrative accountability, not just a one-time grant. But older naturalized Americans are not powerless. In fact, the legal tools available to them are robust. Their response, if it is timely, documented, and professionally guided, sends a message to federal enforcement that this community is legally engaged and not easily caught off guard. And it sends a message to advocates and lawmakers that the 60-plus naturalized community requires active, sustained legal protection, not passive assumption that everything will be fine. As 2026 continues, we expect more details to emerge about the full scope of what federal agencies are reviewing and how broadly these administrative actions will reach. But what we know right now is that informed action is timely. It protects you against surprises you don't have time to address. It creates a documented legal record that works in your favor, and it ensures that the life you built on the foundation of your citizenship is defended by someone who understands the legal terrain as well as the government does. What happens next will depend on what federal enforcement priorities look like in the coming months. If review actions remain targeted and narrow, proactive citizens will simply have confirmed the security of their status and gained peace of mind. If they expand, older Americans who have already taken protective steps will be in the strongest possible position. And tonight, for the first time in a generation, naturalized Americans over 60 appear to be navigating legal terrain that no one told them to prepare for. The community is listening, quietly processing. And when this community gets informed, it does not stay quiet. Because tonight, older naturalized Americans are learning something that no one should have to learn this late, but that everyone needs to know. Citizenship, once earned, must still be protected. Documentation, once filed, must still be verified. And legal rights, however firmly held, are only as strong as the informed action taken to defend them. This story is far from over, but tonight, one thing is clear. The naturalized Americans who act now will be the ones best positioned when the next letter arrives. The ones who wait will face a harder, slower, more expensive road. And the 60-plus community, resilient, experienced, and unwilling to lose what they spent their lives building, has every reason and every tool to choose the proactive path. We will be here, watching every development as the next phase of this story unfolds.